Supreme Judicial Court of the United States is now in session. All rise. Chief Justice Jill Evans and the justices are entering the court. Be seated.
Supreme Court case number 1046, Tinker versus the School Department of Des Moines, Iowa. Arguing for the petitioner are attorneys Mr. Brad McDonald, Esquire, and Mrs. Ellen Parker, Esquire. Arguing for the respondents are attorneys Mr. Mike McKellar, Esquire, and Mrs. Angie Bell, Esquire. Petitioners, you may proceed.
Now I will state the facts of the Tinker v. Des Moines School District case. Petitioner John F. Tinker and his sister, Ms. Mary Beth Tinker, wish to express their feelings about the Vietnam War. They got together with a group of fellow demonstrators and devised a plan to wear black armbands showing their concerns about the war. They decided by wearing black armbands and by fasting on December 16th and on New Year's Day, they could publicize their own opinion of the war. The principals of the Des Moines School District became aware of their intentions and adopted a policy stating that any person wearing an armband to school would be asked to remove it. If they refused, they would be suspended until they returned to school without it. On December 16th, they arrived at school, aware of the new policy, and were asked to remove the armband. After refusing, they were suspended from school. They carried out their plan and returned to school after the New Year. The district court sided with Des Moines and stated that it was within the school's power to stop the wearing of armbands.
Members of the Supreme Court, I wish to state my main argument concerning this case. I believe that my clients, Tinker, have the right provided by the Constitution of the United States to wear the armbands in protest of the Vietnam War. I firmly believe that the wearing of the armband for the purpose of expressing their opinion was in the boundaries of the First Amendment. And the form of expression was orderly and peaceful and was not intended to interfere with the normal school routine. Pure speech is entitled to teachers and students, even in the school environment.
Excuse me, could you please define it?
Pure speech, yes. Pure speech, the boundaries of the First Amendment concerning pure speech are, one, you are not allowed to publicly put down members of Congress or plot against the government. You are allowed for peaceful gatherings and of communion. A statement of a previous Supreme Court case concerning the wearing of a jacket with foul language. The Supreme Court members stated, and I quote, that any four-letter word, no matter how vulgar, is allowed or protected under the First Amendment unless of sexual reference.
How exactly would you want us to interpret the Constitution of the First Amendment?
I would like you, as the members of the Supreme Court, to consider the boundaries of the free speech under the First Amendment concerning that there was no sexual reference in this, and that Des Moines High School school department stopped them from wearing the armbands before any outbreaks within the school had started. They did not even give them a chance for anything to happen. Now, the wearing of the armband was, in my opinion, within the First Amendment. And the school system does not have the right, working on a belief that violence would start, to stop. Students nor teachers shed their constitutional rights when they enter the gates of the school. Fear alone, as an answer to your question, fear alone of a physical demonstration or interruption of the normal acts of the school environment is not a valid reason for denying students or teachers of their rights.
What constitutional rights do students have if they're not even allowed to vote until they're 18 years of age?
I'm glad you asked that. All people of the United States, students, parents, people that are employed, have and share the same rights under the Constitution, even if they are under the age of voting, 18. Now, you do not lose any of these rights when you enter private property, to the extent that you do not damage. You do not lose these rights when you enter a school building or something, a building of the state. You are still allowed to express yourself. Anything else? Children have the right to express their views and hold the same rights as adults of the community. Members of the school faculty are not allowed to stop expressions of feelings which they do not wish to be known by others.
What do you have to back that up?
Excuse me?
What do you have to back that up?
I don't have exact constitutional reference. That is an opinion. But from quotes from previous cases, students have the rights, and they do not shed their rights on. They not only have the rights on the playground or at home in their own house. They have these rights in the school buildings or anywhere where they may go.
You stated that the form of expression is orderly and peaceful. You also said that student behavior is not a reason to deny them of their freedom of speech. Are we supposed to interpret those the same way?
Well, no violence had yet begun because they didn't even, or were not even given a chance to wear it. The moment they showed up at school, they were asked to leave. And I'm sure within a couple seconds they were there was no chance for violence or an uprising in the community of the school. I would like you to interpret that as it is stated. Okay. Students' rights are not limited to the cafeteria or on the playing field. They may express his or her feelings at any time, even concerning controversial issues like the Vietnam War. District Court recognizing the right of the students to wear the black armbands, but said that it was within the school's power to stop this demonstration before it interrupted the school atmosphere. But by ruling this, they did not acknowledge that the students did not have the chance.
Could you define natural right?
A natural right?
Yeah.
A natural right of a person in the United States, rights guaranteed by the Constitution or as a human being. Would you feel